this Mr. Moore's in custody, right?
More is, yes, sir. I've got about 6 or 7 that are.
Let's see the jail there yet. Last time. Well, if it takes long to stare, then defendants yet. Are all of the defendants in jail?
Most, I think we have 7, I think, to start out with in jail.
Okay, because I don't have any defendants on the screen, so.
Yeah.
Got 2 in the office.
Okay, who do you have?
Steve Debo and Dennis Marks.
All right, who's Mr. Debo's attorney? All right, let's do him. About 10 minutes.
Okay. 17. On the record for Debo, 2 cases.
Recording in progress. Recording stopped.
Yeah, okay.
No, not yet. You gonna do Debo first?
Yeah, we'll just tell them that time in about 10 minutes, 10, 15 minutes.
Yep.
There you go. Not the jail, I'm sorry.
Okay.
All right, Mr. Debo, we're going to need to unmute you there. Okay, there we go. All right, you're Stephen Debo. All right. This case, there are 2 cases here, both involving the same defendant. 22 CR 28, 22 CR 39, both styled State of Ohio versus Stephen L. Debo. Debo is appearing by Zoom from the probation department. His attorney is Dennis Kirk. From his office, and prosecuting attorney, assistant prosecuting attorney King is representing the state from his office. Mr. Kirk, you and your client both agree to this matter being conducted by Zoom rather than in-person appearance.
Yes, sir.
All right. You're all right with that, Mr. Debo? All right. The defendant is charged in case number 22 CR 28, along with Drake Haynes. He's charged with counts 3 and 4, aggravated trafficking and meth, and aggravated possession of meth, and a forfeiture. And in case number 22 CR 39, he is charged with counts 1 and 2, aggravated trafficking and aggravated possession. Mr. King, it's interesting. I see you on the screen, and you're asking to be admitted to the waiting room. Or you entered the waiting room. You want to be in here twice, or somebody else using your computer?
I suspect that happened if possible.
Okay. Well, I'll let them in. We'll find out who it is. Maybe. All right. Now, Mr. Debo, they've presented with plea of guilty forms, which indicate that you are going to withdraw your not guilty plea in each of these cases and plead guilty. In 22 CR 28, it says to count 3, the aggravated trafficking and methamphetamine. And in 22 CR 39, it says also aggravated trafficking and methamphetamine. So I'm going to hold these up to the camera so you can see them. This is the first one, 228. Can you see that one there?
Yes.
All right. And then on page 3, there are signature lines, and there's a sentence about halfway down that says, I enter this plea voluntarily, and right below that, there's a signature that looks to be Stephen L. Debo, and I'll hold that up on camera, and is that your signature there?
Yes, yeah.
Alright, then on the other one, this is 39, I'll hold that up, you recognize that one?
Yes, Your Honor.
And on page 3, there are also our signature line, and the same sentence, it says that in the plea voluntarily, right below that appears to be the signature Stephen L. Debo. I'll hold that up to the camera, is that your signature there? Alright, now, when did you sign these agreements, Mr. Debo?
It was last week in
All right.
my attorney's office.
Alright, and he go over both of these with you, explain it to you?
Yes, he did.
And you feel you had enough time to fully consider this matter before you made this decision to sign these agreements?
Yes, I am.
And you still want to go forward with them today?
Yes, I do.
Are you entering into the agreements to plead guilty in each case voluntarily?
Yes, sir, I am.
All right, now, the first case, 22 CR 28 says that you're going to withdraw your not guilty plea to count 3 and plead guilty to aggravated trafficking methamphetamine in the city of school under 2925.03A1 for a degree felony. And that you understand that the maximum penalty for that, if convicted, could be 36 months in prison, the minimum would be 9 months, in certain increments in between, the fine available $10,000, mandatory fine of $5,000, and license suspension of 6 months to 5 years. And then case number 22 CR 39 actually is incorrect, because it says you're pleading guilty to count 3, it actually is count 1, aggravated trafficking, correct, gentlemen? There's no, count 3 is a forfeiture specification in 39.
That's the component.
Alright, so, that's correct, Mr. Kirk?
Yes, Your Honor.
Alright, so for the record, I'm making that change to me. Louis, count 1, aggravated trafficking methamphetamine, same section number and same degree of felony and the same penalty. 36 months maximum prison term, 10,000 maximum fines, mandatory fine of $5,000, possible life suspension 6 months to 5 years. Now, do you understand that, Mr. Debo?
Yes, Your Honor.
Now, if you are convicted of both of these offenses, and if you were sentenced, consecutive sentences being one after the other, then the maximum possible penalty could be 36 months on each count consecutive, which would be 72 months or 6 years. It could be a maximum fine of $20,000. You understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on community control, probation, parole, or post-release control from any jurisdiction?
No, the jurisdiction just here in Long County, Airport.
All right. Now, if you are convicted of these offenses and if you are sentenced to prison, upon completion of the prison term, the law provides that the adult parole authority could, at their option, put you under post-release control supervision for up to 2 years, which means you would be supervised by a parole officer the terms they set. And if during that period of time they felt that you were not complying, then they would have the right to return you to prison to make you serve an additional period of up to 9 months for one violation. But there is a cap or limit on a cap to whatever prison term is imposed for all violations. But if your violation is a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you in that case to an additional period of 1 year, whatever time is left on the period of post-release control, 2 years of post-release control. Whichever greater that occurs, that would be served consecutively the sentence in the new case. You understand that?
Yes, sir.
All right, now, I'm not required to sentence you to prison for these offenses. I can impose what's called community control or probation, meaning that instead of going to prison, you'd be put under the supervision of a probation officer in the county department for a period of up to 5 years as a term set by the court. And if during that period of time, the probation department felt that you were not complying, then at that time, they could file a notification in writing with the court, serve a copy on you. There would be a hearing, you'd be entitled to an attorney. If the outcome of that hearing was that you had failed to comply, then at that time, you could be sentenced to 9 to 36 months in each case, consecutive, a total of 72 months, fine $10,000 in each case, total of $20,000. Do you understand that?
Yes, sir.
Now, case number 22 CR 28, the first count third count alleges that on or about September 23, 2021 in Highland County, Ohio, you didn't knowingly sell or offer sell methamphetamine Schedule 2 controlled substance in the city school zone. In violation of section 29.5.03A1 of the Ohio Revised Code. Count 1 in 22 CR 39 reads that on or about October 10, 2020 in Highland County, Ohio, that Wesley, Howard, and you both did knowingly sell or offer sell methamphetamine, schedule 2 controlled substance amount equal to exceeding bulk amount, but less than 5 times bulk amount. Also under 2925 title 301. So even though they're different allegations, it's still the same offense and the same penalty. You understand that?
Yes, sir.
Now, have you discussed the nature of these charges, the evidence of the case, possible legal issues of the case, possible offenses you might try to raise or try to possible outcome of the trial with your attorney?
Yes, I have, Your Honor.
Are you satisfied with this advice and confidence in this matter?
Yes, I am, Your Honor.
And are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any kind of prescription drugs?
No, sir.
Now, on page 2 of each document, there appears looks like 4 sentences that are printed in bold and underlined. In case number 22, CR 28, it reads, defendant shall enter plea guilty to count 3, state dismiss remaining counts, state defense shall recommend community control, condition defendant cooperate fully, testify against co-defendants, and pay restitution as follows: $170 alone, $120 joint several with fair games. And in case number 22, CR 39, it reads, defendant shall enter plea guilty to count 1, state will dismiss remaining counts, state defense shall recommend community control, condition defendant cooperate fully, testify against co-defendants, and defendant pay restitution as follows: $680 joint several with Wesley. Is that your understanding of the agreement
Yes, it is, Your Honor.
in each case?
Yes, it is, Your Honor.
Now, under the law, Mr. Debo, the matter of sentencing is up to the judge, not to the parties. So even though there's an agreement in this plea that you receive complete control, that's a recommendation only, it's not binding on the judge. So once I've heard all the information submitted to me, if I decide that's not the correct recommendation, I could go ahead and send you to prison in each case for 36 months and fine you $10,000 and suspend your license for 6 months and 5 years. You understand that?
Yes, sir, I do, Your Honor.
All right, now, do you hold any license or certificate from any state governing body that regulates, governmental body that regulates any kind of a profession or occupation?
No, sir.
All right, now you have certain rights you must understand before I can accept your plea. First, you have the right to have an attorney, and Mr. Kirk was appointed to represent you. Now, attorneys aren't appointed simply to work the case out, but to provide any defense that can be available to you under the law that you would wish them to provide. So, if you decide that you don't want to plead guilty, Mr. Kirk will continue to represent you and defend you, including trial, if that's what you want in either or both cases. You understand that?
Yes, sir.
Now, under the Constitution, in each of these cases, you have a right to have a jury trial, in which 12 people will be selected from a group of citizens that are summoned, that live in High County, that are summoned for jury duty on your trial day. After they are selected, the evidence will be produced and introduced, and then the judge will instruct them on the law. And then that jury will decide whether or not the state prove your guilt by proof beyond a reasonable doubt in either or both cases. And that jury's verdict will have to be unanimous, meaning all 12 have to agree on the verdict in each case. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means give up in writing, the right to have a jury trial. And in that case, then you would have what's called a court or bench trial. And what that means is that the judge is the one who hears the evidence instead of the jury. The judge is the one who applies the law and decides whether or not the state proves your guilt by proving beyond a reasonable doubt. You understand that?
Yes, sir, I do.
All right, now, in the Constitution, in each of these cases, you have a right to confront witnesses against you and to cross-examine them to your attorney. What that means is that the witnesses against you in each case have to come in court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions, that's called cross-examination. The purpose of that is to try to bring out evidence that will help your side of the case in each case. You understand that?
Yes, sir.
In each case, under the Constitution, you have a right to either file court, compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses that you're not certain are going to come in voluntarily, at your request, court issues a court order that's a subpoena, and that forces those witnesses to come to court to be able to testify for one of the two, even though they don't want to be here, in the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right now, in the Constitution, you have a privilege against self-incrimination in each of these cases, which means that you cannot be forced give evidence in this matter at any time, including the trial. No one can ever make a testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation, that is, if there's a jury trial and you don't testify. In either case, then the jury is instructed that because that is your right, they cannot consider it for any purpose in that case. You understand that?
Yes, Your Honor.
Right now, in each of these cases, you are presumed innocent until proved guilty by the state of Ohio by proof beyond reasonable doubt on all the essential elements of the offense charged in each case. So what that means is that you're not required to try to prove you're not guilty simply because you're accused in these two cases. In fact, under the law, you don't have to present any evidence at trial in either case. You may, but you're not required to. Whether you present any evidence in either of the cases or not, the burden of proof will remain upon the state of Ohio to prove your guilt on each of these two cases by proof beyond reasonable doubt. Every essential element of the offense charged, which is Ohio's burden of proof, is known under the law. You understand that?
Yes, Your Honor.
Now, you originally entered a plea not guilty plea denied the allegations of each indictment, denied you committed any crime, and that plea exercised or invoked all the rights I just described. Now, if you change your plea from not guilty to guilty in both of these cases, then that is the opposite of the not guilty plea as to that charge. That plea gives up all the rights in each of the cases that I just described for you, except your right to counsel. You always have a right to have an attorney no matter what you're pleading. Well, that exception, your plea of guilty, gives up the right to have a jury court trial. Wage gives up the right to quote witness against you, cross-examine for your attorney. Wage gives up the right to use the power of the court to compel or force witnesses to come into court and testify on your behalf and stand for the state. Wage gives up your privilege against self-incrimination because that's what's you saying you're guilty, and that's what you find you guilty in each of the cases. And in each of these cases, wage gives up your defenses because if you say you're guilty, the state's not required to prove you. So the plea of guilty will waive all those rights in each case. It also subject you to being sentenced immediately by the court. I thought that was the right thing to do. And then finally, wage gives up a right to file an appeal that you think you may have had up to this point in the case. Now, should I sentence you to the maximum sentence in either case, or in other certain limited circumstances, you can file an appeal. That can file for 30 days if your sentence is injured, you file. You understand all of that?
Yes, Your Honor.
And Mr. Devo, are you entering into the plea, agreement to plead guilty in each of these cases voluntarily?
Yes, I am, Your Honor.
And are you a U.S. citizen?
Yes, I am.
And do you have any questions about the charge in either case or the possible penalties?
No, sir.
You understand?
Yes, sir, I do.
Have any questions about the plea agreements in either case?
No, sir, I do.
You understand?
Yes, I do.
Again, you understand the recommendation on sentencing is not binding on the court.
That's correct, I understand that.
Have any questions about the constitutional rights I explained?
No, sir, I don't.
Do you understand those?
Yes, I do.
Do you have any questions about the plea of guilty, what it means, what will happen in each of these cases if you plead guilty here today?
No, sir, I don't.
You understand?
Yes, sir.
I didn't say this at the beginning, but if you need to talk with your attorney about anything, I can push you and him into a breakout room. It'll just be the two of you on the screen talking to each other. No one else will be able to see you here. Do you need to speak to him about anything?
Could I have just a minute with you?
Sure. Should be a button posted up that says join breakout room, and then when you're done, there'll be a button that says leave.
Okay.
You press that, please.
And it's the name again.
It should be, oh, I didn't open it up, I'm sorry.
Okay.
Now it should be coming up.
Thank you.
While we're waiting on him, the gentleman that's on the screen in the green jersey says Relias. What is your name?
Brady Federal, sir.
Okay. And who's your attorney?
Mr. Gerber.
Okay. All right. Well, wait on him to talk to Mr. Tebow. Still in jail. Russell Hill?
Yes, sir.
Okay,
Give me a second here.
that's 22 CR 04. All right, case number 22 CR 004, State of Ohio versus Russell L. Hill. This hearing is being conducted by Zoom. Mr. King is appearing from his office on behalf of the state. Appearing on behalf of the defendant is Jacob Wagner. Defendant is not present, but he was noticed. Mr. Wagner, do you want to make a statement on the record you just made to me?
Yes, sir, Your Honor. I've been texting with Mr. Hill and through phone communication and contact. He got a hold of me Friday. He was at a place called the Hope House in Middletown, Ohio. They're being transitioned to Genesis in Hamilton. We tried to call both facilities and they gave us the standard. We cannot confirm or deny that he is present. I reached back out to Rusty and said I need confirmation from his counselor. I've not gotten anything right at this time. We're just trying to get through to the Genesis to give us something so I can present to the court. We're at a final pretrial today with the jury trial, I think the 21st. We just asked to continue today, maybe reset a jury trial date, Your Honor.
Well, I have a not so good report of the probation department. It says that he failed to show since January 27th. He posted a report on the 31st of January, 7th of February, the 15th of February, and the 22nd of February. On February 17th, he called and talked to Officer Balser and said he would be coming in. However, he never showed. He was also put on the call-in drug testing system where he was supposed to call daily, and then if he was lucky, he would actually report the testing, and he's not done that. So I'm a little skeptical, Mr. Wagner, so what I'll do is this. I don't have your motion, but what I would suggest you do is get back on the phone and tell those folks that they need to go see him if he is in their facility and get him to sign a release so they can call and give you the information, because if you don't have that by tomorrow at 3 o'clock, we're going to issue a papers for his arrest because he's been non-compliant for over a month now on pretrial supervision. And but I will grant your continuance for the trial since he's not communicating with you either. When was the last time you talked to him?
I had a text, Your Honor. I'm looking at it right now. Friday at 3:21.
Well, a lot of times when they go into those facilities, they confiscate their phones or they lock them up. They don't let them have any communication for a few days. I don't know, it varies from facility to facility, it varies on what the person, I mean, if it's a sobering up or drying out place, usually that's about 3 to 4 days, which means you should be past that point. But again, some of them also say no communication through us for 10 days, 2 weeks, whatever. So, what you need to tell them is that, for his good, they need to get it done, because if they don't, we'll issue a capious and tell them that we think he's down in one of those places and the sheriff will come knocking on their doors. And then your client can thank them for not providing the information or getting him to sign a release. But also, it's his fault too. So you can continue to text him and tell him to get your release and information. But I hope for his benefit he is in a house getting treated. But also, from what I've been seeing here from the reports, it sounds like his addiction is not getting any better; it's getting worse. So he needs to get shots right away. All right.
Yes, sir. I'll call him immediately.
All right. Okay. I'll go down at 3 p.m. By 3 p.m. tomorrow or habeas. All right, sir. All right, we'll go back on record on Mr. Debo being back. All right, now everything taken care of in your session, Mr. Debo?
Yes, Your Honor.
Okay, you're still wanting to go forward with this agreement?
Yes, Your Honor.
Okay. Do you have any other questions about anything I would explain to you about these two cases here this afternoon?
No, Your Honor.
Okay. Then is it your decision to move forward and plead guilty in each of these two cases, as described in the plea agreements that we've just gone over?
Yes, Your Honor.
And as to count 3, well, by one, I just noticed Mr. King on count on 228, the maximum penalty, it says it's for count 1. You don't need to change that to count 3. All right, so as to the charge in case number 22 CR 28, count 3, that reads that on or about September 23, 2021, in Highland County, Ohio, you didn't knowingly sell or offer methamphetamine, Schedule 2 controlled substance in the vicinity of school, violation section 2925.03A1, a third-degree felony, aggravated trafficking methamphetamine in the vicinity of the school zone, a penalty of 9 to 36 months in prison, fine of $10,000, up to $10,000, mandatory fine of $5,000, and possible license suspension of 6 months, 5 years. How do you plead?
Guilty, Your Honor.
And then as to count 1 in 22 CR 39, it reads that on or about October 10, 2020, Highland County, Ohio, Wesley Howard, and you did knowingly sell or offer sell methamphetamine, Schedule 2 controlled substance amounting to exceeding bulk amount less than 5 times bulk amount, violation section 29.503A1. Also aggravated trafficking methamphetamine, a third-degree felony, carrying prison term 29 to 36 months. Income provided by law, fine of up to $10,000, mandatory fine of $5,000, and possible license suspension of 6 months, 5 years. How do you plead?
Guilty, Your Honor.
All right, thank you. Court finds on this day open court, defendant was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver pursuant to criminal rule 11. Pleas are accepted order filed. Defendant is found guilty of count 3 in 22 CR 28, count 1, 22 CR 39. That's charged in each count. The remaining count in 39 is dismissed, and in the 28 case, counts 1, 2, 4, 5 dismissed. Court will order a pre-sentence investigation be conducted, including an assessment for a possible substance use disorder and or mental health treatment. Sentencing will be on April 13th, 9 a.m. Bond will be continued. So you're right there at probation already, so you'll need to talk with Mr. Make an appointment with Mr. Fulton for the pre-sentence court. I don't remember what your trial date is, but you won't have to be present for your trial date unless there's a co-defendant plea or being tried, in which case you may be a witness and would have to appear. Anything further, counsel?
There.
And thank you. All right, Mr. Kirk, Mr. Pettiford is there on the screen on the green jersey on it says Reliance on the screen, so we'll go ahead and do that one.
Ready?
All right, case number 22 CR 45, State of Ohio versus Brandon Pettiford. Your Brandon Pettiford appearing there from on the screen is marked Reliance.
Yes, sir.
All right. This hearing is being conducted by Zoom. His attorney is Danny Kirk. Kirk in his office, appearing from the prosecutor's office is advocate. What was it? Where that was going on? They still have ball in.
Yes.
Mr. Pettiford is charged with aggravated trafficking methamphetamine in the vicinity of school, aggravated possession of methamphetamine, 2 counts, and then 1 count of aggravated trafficking methamphetamine. This is a first pre-trial, and I believe that we have a final pre-trial coming up on March 16th and the trial date of April 14th. I see that the state provided discovery and bill of particulars, and have you provided your discovery yet, Mr. Kirk?
I have not been provided that.
All right, well, yours will be like a final pre-trial. Do you participate in pre-trial motions?
Not at this time.
And has there been a written plea offer provided?
I do not see one yet. I would expect it any time.
It was provided on February 23rd. I can put another copy in the box so it's
Okay, yeah, I did not see that come through.
Okay, Okay, all right, anything else we need to discuss then? All right, then we'll see you back on the 16th, Mr. Pettiford. I believe that will be in-person hearings unless there's a request for a Zoom hearing. All right, thank you.
Oh, thank you. Thank you.
All right, now, what's your name, sir, that's at the probation department?
Devin Sparks.
All right. Devin Sparks. Who's your attorney, Mr. Sparks?
He's my client, Your
Okay,
Honor.
Ms. Knappman, all right. Case.
One second. They may be on video out there rather than on Zoom. But
Case number 22 CR 22, State of Ohio versus Devin Sparks. Your Devin Sparks appearing there on the screen marking CPD.
Yes.
All right, Mr. Sparks' attorney is Kat Patner. This hearing being conducted by Zoom. She's appearing from her office and appearing from the prosecutor's office, Assistant Prosecutor After King. Defendant is charged along with looks like 6 other co-defendants. He is charged, it looks like he counts 17 and 18. I believe that's only 2 charges. He is charged with aggravated trafficking, 17% of school, and aggravated possession of felony, along with Jennifer Heiss. This is a first pre-trial. The final pre-trial set to March 16th, and the trial date April 11th. Now, the prosecutor provided discovery, and have you done your yet, Ms. Packer? Alright, we do by the final pre-trial. Do you anticipate any pre-trial motion?
Not at this time.
Okay. And has been a written plea offer provided?
I have received that, Mr. Sparks and I have been exchanging phone calls, but I have not actually spoken, so that he will give me a call back, or someone in my office, if you have a copy of this discovery of the plea offer.
Okay. Maybe we should do that as soon as we get done here, Mr. Sparks, since you're the probation whenever you're done there.
Yes, sir.
All right, anything further then from counsel?
No, Your Honor.
All right, then, March the 16th, and like I said, right now, we're planning those being in person unless there's a request from Zoom. Thank you.
Thank you, Your Honor.
All right, thank you. I'll stop by your office.
Okay, thank you.
Yes.
All right.
I think everything else is jail. We have Mr. Anderson here who, Mr. Armentrout, he was supposed to be Zoom, but he told me beforehand he may be going private attorneys. So,
Mr. Armentrout, you have Mr. Moore?
Yes.
He's at the jail. Is that the only one we have?
Chance for Anderson and, one Anderson, pickle term, only.
All right. Well, what's your name, sir?
McQuan Anderson.
All right, come on up here. Juan Anderson is president of corporate, Mr. Armentrout, so we're going to go ahead and do this while we're waiting on the jail. 21 CR 160 for that case. All right, and you can take your mask off to speak and please try to speak up so they can hear you since they're on the Zoom. Okay, Mr. Anderson is charged with the 6-count indictment, case number 21 CR 160, State of Ohio versus Juan Anthony Anderson. He is present in the courtroom. This was set to be a Zoom hearing. He doesn't have the ability to do that apparently. So his attorney is William Armentrout. He's on the Zoom screen along with Assistant Prosecutor King, but we have that other case we're waiting on. Looks like the jail did sign in. Now, Mr. Anderson is charged with 3 counts of aggravated trafficking, methamphetamine, and 3 counts of aggravated possession. This is a first pre-trial, and the let's see if I can find that. Yeah. Actually, it's the final pre-trial, and no, first pre-trial, final pre-trial on March 16th, trial date is April 11th. And I see that the discovery was provided, and Mr. Armentrout asked for discovery and bill particulars, and that has been provided. You have not done your discovery yet, Mr. Army trial,
Prepared, Your Honor, has not been filed.
all right? And, at this point, you participate in pre-trial motion,
Well, I don't, Your Honor, I haven't spoken with my client yet.
okay? All right, we'll talk about that here in a minute. And it's been a written plea offer.
Yes, it has been.
Okay, well, since he hasn't spoken with his client, I'm sure he's not aware of that. And you participate in pre-trial motion for the Army trial?
Not that I'm aware, Your Honor.
Okay, all right, well, that's good, change off. All right, Mr. Anderson, looks like you were released from Montgomery County back February 14th, and, they couldn't get you after you were, taken off here?
Yes.
All right. Well, you were supposed to report as soon as you were released, and that includes in Montgomery County, and that's 14th, so you should have been down here on February 15th, the next day, and that was a Tuesday. So as soon as we're done here, you're gonna go to report to them, right down the street, 117 East Main Street. On the other side of the street, down past the light, sits on an alley, got a brick front, across from the gas station, the flag. Now, also, you need to get in touch with Mr. Armitrout. You want him to stop by your office and make an appointment, Mr. Armitrout? Get his stuff?
This would not be a good time, Your Honor, I'm the only one here.
Okay, I know you've got several hearings, all right. When would be a good time for him to get in touch with you?
Judge, can you ask me, there's a phone number on his, financial form, 513-773-1116, can you confirm?
Is that your number?
Like, I got a different number that I can be contacted.
All right, what's your number?
937.
937?
Yes, 537.
537?
Yes, 9855.
9855. 937 537 9855.
He'll be contacting you this afternoon, first thing in the morning, to schedule an appointment to come in here.
Okay. All right. So as soon as we get done, you're going to write down probation and report down there. And you have to report there once a week for 4 weeks, Mr. Anderson.
Okay.
As part of your bond conditions. And take Mr. Anderson, Mr. Armstrong's phone call, make your appointment.
Okay.
All right. Anything further we need to discuss?
There you go.
All right, thank you. All right, go ahead, Joe. Anderson, thank you.
Is it possible not to write the address?
Pardon?
The address of the patient?
Oh, it's 117 East Main. Right there's a light. You just go right on the other side of the street down to the alley. First alley, it sits on the alley. It's a direct front building. It has a Hyden County probation department. All right, we need Joshua Moore. All right, just, are you Joshua L. Moore? Oh, you'll have to, unmute your, screen there. The button down the left-hand corner says mute or unmute.
Can you hear us now, sir?
Yes, thank you. All right, now, you are Joshua L. Moore?
Yes, sir.
All right, this is, there are 3 cases here involving Mr. Moore. Case number 21 CR 144, 22 CR 26, 22 CR 44. All table have Mr. Joshua L. Moore. Mr. Moore is appearing by Zoom from the jail. His attorney is William Armitrout, appearing by Zoom from his office, along with Assistant Prosecutor King from his office. Now, Mr. Moore, since you're not, well, first of all, Mr. Armitrout, you and your client are both waiving his presence in the courtroom and agreeing to this matter proceeding by Zoom rather than in person.
Yes, we are, Your Honor.
And you're all right with that, Mr. Moore?
Yeah.
All right, thank you. Now, Mr. Moore, since you're not in the courtroom with your attorney sitting next to him, if you need to speak to him at any time, just tell me. I'll put the 2 of you into a breakout room so that you and he can talk. No one else will be able to see you and hear you. Okay?
Okay.
Now, in 21 CR 44, Mr. Moore entered a plea of guilty to believe, breaking and entering back on December the 3rd, and set for sentencing in January, and failed to appear, and then he was taken into custody, I think, maybe on the 7th of February, at least he appeared before the court, and There was a hearing originally set to sentence on February 16th, and then that was postponed for today. And then in the meantime, he was indicted in these other two cases, 22 CR 26 for failure to appear in the 21 CR 144 case. Then in 22 CR 44, he was indicted on 3 counts of aggravated trafficking and methamphetamine, and 3 counts of aggravated possession of methamphetamine, all 4 degrees of trafficking and 5th degrees for the possession. Now, I believe this is set today for pre-trial, but I have been provided with, and sentencing on the 144 case, but I've been provided then in these other 2 cases, Mr. Moore, with,
Gentlemen, if I could interrupt you for a minute, I need to speak to Josh for about a minute in the breakout room if I could.
oh, okay, no problem. Record of State versus Joshua L. Moore. For Mr. Armitage, you've had an opportunity to finish your consultation then?
Yes, Your Honor.
All right. Are we still going forward then?
Yes.
All right. Now, Mr. Moore, I've been presented with plea of guilty forms, which indicates that you're going to withdraw your not guilty plea and plead guilty in each of these cases. The plea form in 22 CR 26 says you're going to plead guilty to the failure to appear, and I'll hold that up here to show you. And recognize that form there, so, right? And on page 3, there are signature lines, and again, I want this screen over here. Get that back. I can't open it. There's a sentence on page 3 that says, "I enter the plea voluntarily." Right below that, there's a signature which I'll have to give you credit that I can't read it. Long scribble. I'll ask you if that's your signature.
Yes, sir.
Alright, and then in 144, says you're going to plead guilty to 1, 3, and 5. And I'll hold that up the first page, you recognize that?
Yes, sir.
And then on page 3, there are signature lines in the same sentence, about halfway down. I enter this plea voluntarily, is that your signature? Right there, I'm looking at you. Okay. When did you sign these agreements, Mr. Moore?
Yes, sir.
All right, actually, I think what happened actually on this one, Mr. Armstrong, I'm going to pull that up, I think, you signed on the attorney line, and the attorney signed on the defendant line. Let me confirm that. Am I right on that? That second signature is yours, isn't it, Mr. Moore?
Yeah.
All right, and the top signature is yours, Mr. Armstrong, right?
Yes, it is.
All right. Assuming for purpose of this case, you're not switching places. So, he's not listening. Okay. Anyway, we're having a good laugh at your expense, Mr. Armstrong. I guess you're not listening, so.
That's nothing big.
Okay. All right. Now, and Mr. Moore liked me too, but he was listening. So, okay. Now, Mr. Moore, when did you sign these agreements?
Yes, correct.
All right, and is Mr. Armstrong there with you to go over them and read them to you, explain them to you, and answer any questions you might have?
Yes, sir.
And do you feel you had enough time to fully consider the matter before making the decision to sign these agreements and plead guilty?
Yeah.
And did you enter into each of these agreements voluntarily?
Yes, sir.
Pardon me?
Yes, sir.
Okay, there was I did a picture up there, something happened to my, or my speaker, one of the two. All right, now, in case number 21 CR 144, it says you're going to plead guilty to failure to appear under 2937.99 revised code 4-3 felony. And it states that you understand that the maximum penalty for that could be 18 months in prison. The minimum is the prison term imposed is 6 months. There could also be a fine of $5,000. Now, on the other 22 CR 44, where it says you're pleading guilty to counts 1, 3, and 5, all of those are aggravated trafficking methamphetamine. All of them are a violation of 25.03A1 revised code. All of them are 4-3 felonies. So they have possible penalty also of 18 months maximum each, minimum of 6 months if prison term imposed, and a maximum fine of $5,000, mandatory fine of $25,000, and a possible license suspension of 6 months to 5 years. You understand that? Now, under the law, Mr. Moore, if you are convicted of these offenses and sentenced to prison, the sentences can be ordered to be served consecutively to one another in each of the convictions. So there's 3 4-3 felonies in 44, so 3 times 18 is 54 months. And then 18 months in the 26 case, so that would be 72 months, which is 6 years. And then in the other case that we're here for sentencing on is, I think you pled guilty to just count 1, and that's 12 months, actually, 5, 53 felonies. So that'd be a potential sentence of 84 months. You understand that?
Sure.
And then the fines would also be multiplied, so there'd be 4 $5,000 fines possible for the 4-3 felonies, which is $20,000, and then $2,500 on the 5-3 felonies. So that's a total possible of $22,500 fine. You understand that?
Sure.
Okay. Now, are you facing any other felony charges in any other jurisdiction?
That's around, I'm on probation in Stark County.
Stark County, I was going to ask you that next. So, in the event that you're convicted of these offenses, I don't know, when did you get probation up there?
September.
September? Okay.
I think around September, you know.
All right. Well, I'm not sure if these offenses were committed after September or not. Doesn't look.
The failure to appear was, the other two.
The others were not. Yeah. Okay. So, it's possible, just the reason I'm bringing it up, Mr. Moore, is it's possible that you're convicted of these offenses. If any of them occurred while you were on community control in Stark County, they could decide to terminate you, and the judge would have to agree to that. Probation is there to try to get you terminated, and if the judge agreed, then you can be sentenced on that charge in addition to these charges in a second. You understand that? All right. Now, in all of these charges, if you are convicted and sentenced to prison, once you complete the prison term, the law provides that the adult parole authority may, at their option, put you under what's called post-release control supervision for a period of up to 2 years. What that means is that you would be supervised by a probation officer or a parole officer in the terms and conditions they set, because the court is not involved with that. And if during that period of time of up to 2 years you were found to have violated those conditions, then the parole authority can return you to prison, making you serve an additional period of 9 months for any one violation. But there is a cap, a maximum of half of your prison term for all violations. But should you commit a new felony while under post-release control in these cases, then in addition, whatever sentence the judge in a new case would impose upon you, that judge could also sentence you in this case to an additional period of 1 year, whatever time left on that period of post-release control, whichever is greater. If that occurred, they would have to be served consecutively the sentence in the new case. You understand that? So, now, under the law, I'm not mandated to sentence you to prison for these offenses. I can impose what's called community control. And what that means is that instead of being sent to prison, you'll be put under the supervision of a probation officer on the term set by the court. And if during that period of time the probation department felt that you were not fine, then at that time they could file a notice of that with the court. You would be entitled to have a hearing, and if the outcome of that hearing was, and be represented by an attorney, and if the outcome of that hearing was that you were in violation, then at that time the court could terminate you from community control, then sentence you to the maximum on each of these counts, three counts in the 44 case and the single count 26 case, and order those to be served consecutively like we talked about earlier. You understand that? All right, now, the charge in 22 CR 26, I should say, reads that on or about January 6, 2022 in Huntington County, Ohio, you did recklessly fail to appear as required in Huntington County Complexities Court case number 21 CR 0144 after having been released pursuant to ORC Section 2937.29 and released with a connection with charge of commission of felony in violation of Section 2937.99. So that's the charge of failure to appear for the felony. Now, in the counts 1, 3, and 5 in the 2244 case, first count reads on or about October 8, 2020, in Huntington County, Ohio, you did knowingly sell or offer methamphetamine, Schedule 2 controlled substance. Count 3 alleges you did the same thing except it was on January 31st, 2021. Count 5 alleges the same offense on February 7th, 2021, otherwise the same. And all three of those are also the fourth degree felonies, just like the 26 case with a possible prison term between 6 and 18 months each. Fine of $5,000 and a mandatory fine of $2,500 on drug cases, and a 6 months, 5 year suspension of drug cases. Just a fine of prison term in the 26 case, and it's not mandatory. Now, Mr. Moore, do you understand what it is you've been charged with in each of these 4 charges we're talking about in these 2 cases? What the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed each of these charges with your attorney, the evidence in the cases, the possible legal issues, possible defenses to be raised at trial, and possible outcomes of the trial?
Yes, sir.
Are you satisfied with his advice and confidence in these matters?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Now, have any threats been made against you to plead guilty?
Yes, sir.
All right, now, on case number 22 CR 26, the agreement on page 2 has several lines that are printed in bold and underlined. Says, defendant shall enter plea of guilty to the indictment. State defendant, this is a very clear charge. State defendants jointly recommend 9 months incarceration consecutive to other cases. State will not oppose judicial release to Star after 6 months incarceration. Defendant agrees to make restitution to Highland County Task Force for amount of $320 as consideration for plea, and the state agrees not to pursue a felony-free escape charge. Is that your understanding of the agreement in that case?
So,
Now, in the 22 CR 44 case, the underlined bold printed is right at the bottom of the page, page 2, and it reads, defendant shall enter a plea of guilty to count 1, count 3, and count 5. State will dismiss remaining counts. State defense jointly to recommend 12 months on count 1, consecutive to 9 months on count 3, consecutive to 9 months on count 5, consecutive to other cases. State will not oppose judicial release to Star. After 6 months incarceration, defendant shall pay back $5 million to Highland County Task Force, amount of $200. State agrees not to pursue felony-free escape indictment. Is that your understanding of the agreement?
yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
Yes, sir.
Under the law, Mr. Moore, the court is not bound by the sentencing recommendations of the parties. So even though there's an agreement that you receive a specific sentence in each of these 4 counts in the 2 cases, I'm not obligated to follow that. So if you do plead guilty, once I've heard all the information submitted, if I decide that's not the right sentence, I could impose a greater sentence if I thought that was appropriate, or a lesser one, for that matter. You understand that?
Yes, sir.
And as to the situation of judicial release, that is up to the judge as well. Even though the state's not objecting to it, the court isn't promising that you'll get that, because I never know until the motion's filed and I see what the information is at that time. So if I decide at the time that you file a motion and you go to prison, that you should be given judicial release, you need to understand that. It's not guaranteed by any means at all. You understand that?
Yes, sir.
You understand that these 2 charges would be, or would be, I think are being recommended to be consecutive to the charge that you were facing sentencing on before, the 21 CR 144 case.
Yes, sir.
Okay. All right, now, do you have any questions? No, wait, I haven't gone through that yet. Sorry, got ahead of myself. Trying to keep track of 3 of these cases at once, a little bit confusing. All right. Now, you don't hold any license or certificate from any state governmental regulated body for any occupation or profession, do you?
Yes, sir.
All right. You have certain rights you need to understand before I can accept your plea of guilty in these cases. First, you have the right to have counsel. Mr. Armstrong was appointed to represent you, not simply to work the cases out, but to provide any defense that might be available to you at the law that you wish to provide. So, if you decide you don't want to plead guilty in either of these cases or both, then he'll continue to defend you in a trial in each of those cases if that's what you want. You understand that?
Yes, sir.
Right now, in each of these cases, you have the right to have a jury trial, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty after a trial date. After the jury is selected in each case, the evidence will be presented and that jury will be instructed on the law. And then they will decide in each case whether or not the state proves you guilty, and proves beyond reasonable doubt, any or all of the charges. And in each case, the verdict would have to be unanimous, meaning all 12 of the jurors would have to agree. Now, if you decided you didn't want to have a jury trial in either of both cases, but you did want to plead guilty, you can waive in writing, which means give up the right to have a jury trial, and in that case, you would have what's called a court or bench trial. And what that means is that the judge will be the one to prepare the evidence in that case, apply the law, and decide whether or not the state proves you guilty or proves beyond reasonable doubt. You understand that?
Yes, sir.
All right, now under the Constitution, you have a right to confront the witnesses in each of these cases and to cross-examine them through your attorney in open court. So, what that means is that the witnesses against you have to come into this courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor is done asking questions, those of those witnesses and your attorney could ask questions. That's called cross-examination, the purpose of which is to bring out evidence to help your side of the case. You understand that?
So,
now, under the Constitution, you have the right to use the power of the court in each case to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses in either or both cases that you don't think will come in voluntarily, you request the court issues a court order called subpoena. That forces those people that are named in the subpoena to come to court and be able to testify if you want them to. even though they don't want to be here, which is the same way the state's witnesses, of course, come into court and testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege in each of these cases against self-incrimination, which means you cannot be forced to give evidence or to testify in these matters at any time, including the trial. No one can ever make you testify. The prosecutor can, the judge can. It's your decision. If you decide not to testify, the fact that you did not testify, not be using against you in any way of any person, no one's even comment about it, except in one situation. If there's a jury trial and you're going to testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent in each of these cases until proven guilty by the state of Ohio on every essential element of each offense. What that means is the burden of proof isn't on you to try to prove you're not guilty. The burden of proof is upon the state to prove that you are. In fact, at trial, you don't even have to present any evidence in your own defense. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof is known under the law. You understand that?
Good.
All right, now, originally you entered pleas of not guilty to these charges. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and then exercised or invoked all the rights that we just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. That plea waives gives up all the rights that I've just described for you, except the right to have an attorney, because you always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty waives gives up the right to have a jury or a court trial, waives gives up the right to confront witnesses against you and cross-examine through your attorney, waives gives up the right to use the power of the court to compel a court witness to come to court to testify for you, just like the state. Waives gives up your privileges of self-incrimination, because you're saying you're guilty in each case, and that's what you find guilty in each case. The waiver gives up your presumption of innocence, but the state you're guilty, and that's what you, then the state doesn't have to prove you're guilty in your case. It also subjects you to being sentenced immediately by the court, which is what's likely to happen today. And finally, it waives up a right to file an appeal in either of these cases that you think you could have had up to this point in the case. Now, if I should sentence you to maximum sentence, or under certain circumstances, you can file an appeal. That would have to be filed within 30 days if you're sentencing it for just filed. Now, do you understand all that, Mr. Moore? And are you a U.S. citizen? Now, do you have any questions about the charges in either case or the possible penalties? Pardon?
Yes, sir.
All right. And you understand?
Yes, sir.
Okay. You need to speak up. I'm having trouble hearing you. Now, do you have any questions about the plea agreement in either case?
Yes, sir.
All right. I think what's happening is you're having a little problem out there. I think we're losing you with a break out there.
It's internet connection.
Yeah, I think it is, because no one else has a problem. It's kind of wavering. All right. Do you have any questions about any of the constitutional rights that I've explained?
Yes, sir.
You understand them?
Yes, sir.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
Yes, sir.
You understand it?
Yes, sir.
Is there anything else you'd like to speak to Mr. Armentrout about before we go any further?
Yes, sir.
I do,
Okay.
before we get to sentencing, we can go ahead and do the pleas.
Okay. All
Before we
right.
get to sentencing.
Do you have any questions about anything that I have explained here today, Mr. Moore?
Yes, sir.
Then is it your decision to go forward and plead guilty to the failure to appear charge at 22 CR 26 and the 3 aggravated trafficking methamphetamine charges at 22 CR 44, according to the terms of the plea agreements that we've just gone over?
Yes, sir.
And then as to the charge at 22 CR 26 that alleges on or about January 20, I think it was January 21, no, sorry, January 6, 2022, Highland County, Ohio, you did recklessly fail to appear as required. Highland County Complex Court case number 21 CRO 144 after having been released pursuant to ORC 2937.29. And the release was in connection with the charge of a felony and violation of section 2937.99 in the Ohio Revised Code, the charge of failure to appear. a fourth-degree felony carrying possible prison term 26 to 18 months, and a fine of $5,000. How do you plead?
Guilty.
All right, as to the charges in count 1 and 22 CR 44, which reads that on or about October 8, 2020, in Hyden County, Ohio, you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance in violation of Section 2925.0381 of the Ohio Revised Code, the charge of aggravated trafficking of methamphetamine, fourth-degree felony carrying possible prison term 26 to 18 months, a fine up to $5,000, mandatory fine of $2,500, and possible license suspension 6 months to 5 years. How do you plead?
Guilty.
As to count 3, which alleges the same offense, with the same penalties, except that it occurred on January 31, 2021, how do you plead?
Guilty.
As to count 5, which alleges the same offense with the same penalties, except the date is October 7, 2021, how do you plead?
Guilty.
Okay, thank you. The court finds that on this day, open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of the same, sent from rule 11 in each case. The pleas are accepted for the file is found guilty of count 1, failure to appear in 22 CR 26, and counts 1, 3, and 5, and 22 CR 44 aggravated trafficking methamphetamine is charged therein, and then the counts 2, 4, 6 in that charge, in that case, will be dismissed. Now, you would like to have a breakout session, Mr. Trump?
Yes, sir. It'll be right, it'll be short.
All right. All right, that button should come up here shortly.
Back on.
All right, back on record then with Mr. Moore, and we're ready to proceed then with sentencing in all 3 cases, Mr. Armstrong.
Mr. King, it's my understanding that the recommendation for was a total of 48 months, is that correct? If I did the math right.
I know the recommendations are what they are in the plea forms in the 2 new cases, and the state would be recommending 9 months in the original case. Whatever that comes up to.
It says he doesn't know. He didn't ask about it.
48 months, Your Honor, I think.
Okay. Well, look here. In 44, it has 12 plus 9 plus 9. That'd be 18 and 12 is 30. And in 26, it is 9, so that's 39. And 9 months and 21 CR 44, so that'd be 48 months. Yep. Okay. The 2 lawyers agree on it, can't be wrong. All right. Now, anything you'd like to say, Mr. King?
Only was contained in the plea agreement, Your Honor.
Mr. Armstrong?
Just a second.
Well, Your Honor,
You're talking about
First case.
This
It's
happened.
hard to talk over Ms. Hapner.
I just muted her, and I like doing it. So.
You have that power.
I love that. That's the most important part of this job, is being able to mute somebody. Yeah. Go ahead.
I don't have that power with respect to Ms. Hannah. Josh didn't appear for his first sentencing, Your Honor. The court's obviously aware this is all drug-related. His trafficking charges for trafficking, which he's admitted to, but they were, small amounts basically to get drugs to satisfy his own problem. He's cooperated with me. We'd ask the court to follow the recommendation. Obviously, in the future, we hope the court will give serious consideration to an early release to a program which he desperately needs.
All right, Mr. Moore, is there anything that you would like to say regarding these matters of sentencing? All right. Well, then, with regard to case number 21 CR 144, it's a judgment for the court that the defendant be sentenced to a period of 9 months incarceration at the Correctional Reception Center, Moran, Ohio. According to the sheriff's calculations, there's 27 days jail time credit. He had been in back in August, and some periods back earlier, but he was serving a sentence out of municipal court, 30 days on 21 CRB 00703. So I had a total of 51 days. 24 of those would apply to that other misdemeanor case. So just 27 days on that charge. On the failure to appear, the court imposes a sentence of 9 months to the correctional reception Moran. There's no jail time credit on that. It's all been applied in the first case. And in 22 CR 44, the court sentences him on count 1 to a period of 12 months, and count 3 to a period of 9 months, and count 5 a period of 9 months. All of those run consecutively to each other, and 22 CR 44, and each of the 3 sentences in each of the 3 cases, the court will be served consecutively to each other. The court finds that, first of all, this is a pre-recommended sentence. The court's approved it. Secondly, he committed offense in 22 CR 26 while he was awaiting trial in 21 CR 144. There are 3 separate courses of conduct, and 1 single sentence does not adequately reflect the seriousness of the offenses and the harm that's caused by the various offenses, and the sentences imposed are not disproportionate to the seriousness of the offenses. The court will not impose any fine or will fine and waive any mandatory fine in the 22 CR 44 case, and there will be no license suspension in the 22 CR 44 case either. Now, Mr. Moore, upon completion of his prison term, if he served all, the adult parole authority may, at their option, place you under post-release control supervision for a period of up to 2 years. If they do that, you'll be supervised under the conditions that they set because the court's not involved with that. And if during that period of time they determine that you have not complied, then they can return you to prison, even though you serve the entire term set by the court, for an additional period of up to 9 months for any one violation, but there is a cap of half of your prison term for all violations. But if you commit a new felony while you're under post-release control supervision, then in addition, whoever sentenced the judge in the new case proposed that judge would also sentence you in this case to an additional period of 1 year, or whatever time left on the 2 years of post-release control, whichever is greater. If that occurs, it has to be served consecutively to sentence in the new case. And you're also ordered to pay the court costs which judge will grant execution order, and if you fail to do that, then the court could collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but upon completion of it, the court could order you to do community service and give you credit in this county and give you credit for each hour you work in an hourly rate set by the court. And each hour you work will reduce your judgment by that amount until paid for. All right, so you'll be held in custody until you're conveyed to the institution from the sheriff's department. Is there anything further to counsel?
I don't think restitution was ordered, Your Honor.
Oh, no, it was not. Let's see, what was the restitution of the crime? It's in 44 cases.
In the 44 case, it was $320.
All right, so that's ordered to be refunded to the Hyde County Drug Task Force?
I misspoke. In the 44 case, it was $200 to the Highland County Task Force.
$200 is ordered in that case.
The 26 case is 320 to the task force.
All right, 320 in the task force in that case. All
And
right.
did the court, jail time credit in the 22 CR 26 case, was it 0?
Yes. All the credit was applied to the first case. Yes.
Okay, thank you.
All right, thank you. All right, we need Chad Burgess next there, Deputy. Mr. Kirk, are you have anybody else, Ms. Tapper's going to cover for Ms. Will on the Burgess case?
Yes, I have, Kayla Cheney.
Okay.
She's in the jail.
All right. Let me get this Burgess case done. You'll have to unmute Ms. Hapner. I muted you while you were chatting, and I'll have to say that it received a standing ovation from everybody. So, they all wish that they had the power.
I'm sorry, I stepped out in the hallway, didn't realize it was still picking up.
All right. Are you Chad Burgess appearing there from the jail?
Yes, sir.
All right. This is case number 21 CR 149. State of Ohio versus Chad Burgess. This hearing is being conducted pre-trial by Zoom. Mr. Burgess, your attorney is Danielle Witt, but she had to leave to get to Adams County because we had a delay in getting the jail booked in. And so Ms. Hacker, who's is in the same building as her, is standing in for her. So the defendant's charged with aggravated possession of methamphetamine, fifth-degree felony. This is the first pre-trial. We'll have a final pre-trial on March 16 and a trial date of April 14. Okay, it looks like Ms. Witt requested no particular discovery, and it looks like that was provided on the 28th. So I assume you haven't got discovery back from her yet, Mr. King.
That's correct, Your Honor.
And did you get the bill of particulars to her as well?
Yes, that was provided on February 24th.
All right, I didn't see it going through there, it's probably in there. All right,
And then,
so if you would tell Ms. Witt that her discovery will be due by the final pre-trial Ms. Hacker, and then I assume that you may not have had a chance to she indicate whether she thought there would be pre-trial motions or not.
She did not indicate that there would be a pre-trial motion. She did indicate to me that she would be out after she gets back from Adams County to go out to the jail to visit with Mr. Burgess and convey the plea offer to him that.
Okay, so she has a written plea offer. Okay, all right. Anything else that needs to be discussed?
Not that I'm aware of.
All right, so your attorney will be out to see Mr. Burgess either today or tomorrow, whatever.
Sir, can I get a phone number?
No? Any other questions?
I didn't hear it. What about on February?
Yeah, okay, so, the problem is your history is the reason I set your bond. And so, if you can make your bond, you can get out, but otherwise it's going to stay the same. All right? Thank you. All right, and,
Mr. Kirk has,
get Kayla Cheney here next, please.
Are you familiar with this?
That's your client, right, Mr. Kirk?
That's correct.
Yeah, okay.
I understand.
All right, are you Kayla Cheney appearing there from the jail?
Yes.
Okay, this case number 22 CR 25, State of Ohio versus Kayla D. Cheney. This hearing is being conducted by Zoom. Mr. Kirk is her attorney appearing from his office by Zoom. Appearing from the prosecutor's office is Mr. King, assistant prosecutor. Defendant charged along with 6 other co-defendants with drug offenses. It looks like she is charged in count 25, aggravated possession, methamphetamine, and 26, aggravated possession of methamphetamine. Okay, those are only 2. All right. This is a first pretrial, and then final pretrial is set for March 16, and the trial date is April 11. Now, looks like the discovery has been provided, and Mr. Kirk, have you provided your discovery yet?
And not yet, Your Honor.
All right, well, we do by final pretrial. Do you anticipate any pretrial motion?
Not at this time.
And has there been a written plea offer provided?
There has, and I relayed that to my client.
All right? And any other matters need to be discussed then at this time? All right, we'll see you on the 16th then. I'm going to, like I said, I'm planning on doing all of those in person unless there is a request for Zoom. And depending on what the jail situation is, I think it's easier for them to do these by Zoom. And so, officer, you can just talk to the lieutenant and see what goes on with that. To the extent we can, we'll do Zoom hearings to accommodate the sheriff and any other person that have unusual issues. All right, thank you. All right, would you bring us Chancellor Krebs next, please? I can hear Miss Collins cackling there.
That we need to mute back on her also.
Yeah. If you have a clock there in the cow, Mr. King, would you please take care of that?
On the record.
All right. People never knew how much fun court could be. So. All right. Case number 22 CR 008, State of Ohio versus Chancellor S. Krebs. Are you Chancellor S. Krebs appearing from the jail?
Yes, sir.
All right. Now, this hearing is being conducted by Zoom. Mr. Krebs' attorney is William Armentrout. He's appearing by Zoom in his office. And appearing on behalf of the state is Assistant Prosecutor King. Now, this hearing is being conducted by Zoom rather than in person, so Mr. Armentrout, you and your client both were able to hear me conduct in that manner instead of in person in courtroom.
Yes, Your Honor.
And you're okay with that, Mr. Krebs?
Yes, sir.
All right, now, since you're not with your attorney in the courtroom, Mr. Krebs, if at any time during this hearing you would like to speak with him privately, just tell me, and I can put the two of you into a breakout room, and you'll go into a separate area of the computer, and it'll only be you and him talking. No one else will be able to see you here. You won't be recorded, okay?
All right, can we do that real quick?
Sure.
Please?
Absolutely.
We're ready to proceed, Your Honor.
1 minute.
All right. Now, Mr. Krebs is charged with grand theft of a motor vehicle and aggravated possession of a fentanyl-related compound, a 4th and a 5th degree felony. And let's see. Fine, we're done. This is a final free trial, and the trial date is set for March the 21st. Now, Mr. Krebs, I've been presented with a plea of guilty form, which indicates that you are going to withdraw your not guilty plea to count 2 and plead guilty to that charge. And this is a 3-page form the prosecutor's office prepares. It has your name and case number. And we'll show you the first page, which says there's going to be a plea to count 2. You see that form? Recognize that?
Yes.
On page 3, there are signature lines. And about a third of the way down, there's a sentence that says, I enter this plea voluntarily. And then immediately below that, signature that looks like Chancellor S. Krebs to me. Is that your signature there on the line above which is printed signature defendant?
Yes, sir, that's mine.
Okay. When did you sign this agreement, Mr. Krebs?
Why?
When?
Oh, I'm sorry, yesterday.
All right. And did Mr. Armstrong come out to the jail and go over with you and explain everything to you before you signed it?
Yes, he did.
And do you feel that you had enough time to fully consider the matter before making a decision?
Yes, I do.
You don't feel you were rushed or pressured in any way into doing this?
Yes, sir.
You're entering into this agreement voluntarily?
Yes, sir.
All right, now the agreement states you're going to plead guilty to count 2 of aggravated possession of fentanyl-related compound under 2925.11 Revised Code of 5th degree felony. Further states on page 1 that you understand that if a prison term is imposed, the maximum term could be 12 months, the minimum would be 6 if one's imposed. There could be a fine of up to $2,500. There could also be a suspension of your driving privileges of 6 months to 5 years. You understand that?
Yes, sir.
Now, are you facing any felony charges anywhere else?
No, sir, not yet. I don't believe so.
And are you currently on probation, community control, parole, or post-release control for a felony from any other jurisdiction?
Yes, sir.
Now, under the law, if you should be convicted of this offense, and if you should be sentenced to prison, once you complete the prison term, the law provides that the adult parole authority has the option, if they want to exercise it, to put you under what's called post-release control supervision for a period of up to 2 years. And if they do that, you'll be supervised by a parole officer on the terms they set. And if during that period of time they find that you have failed to comply with those conditions, then they can return you to prison, even though you served the entire term ordered by the court, for an additional period of up to, in this case, half of your prison term for 1 or more violations. But if you commit a new felony while you're under post-release control, in this case, then in addition, whatever sentence the judge in the new case would impose, that judge could also sentence you, in this case, to an additional period of 1 year or whatever time is left on that period of post-release control, whichever is more or greater. If that occurred, that had to be served consecutively the sentence in that new case. You understand that?
Yes, sir.
Under the law, I'm not required to sentence people convicted of this offense to prison. I can't impose community control, which means there's no prison, but instead you're put under supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time the probation department feels you're not compliant, they will file a written notice at the court. There will be a hearing in which you would be represented by counsel if you wish. And if the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and then sentence you to prison for 12 months and fine you $2,500. You understand that?
Yes, sir.
Right now, the charge in count 2 alleges Mr. Krebs that on or about December 28, 2021 in this county, and as a continuing course of criminal conduct in Ross County, you did knowingly obtain, possess, or use a Schedule 2 controlled substance with a fentanyl-related compound, violation section 2925.11 of the High Rise Code. So that's the charge of aggravated possession of fentanyl-related compound, which carries possible prison term, as I said, between 6 to 12 months, fine of $25, possible license suspension of 6 months to 5 years. Now, Mr. Krebs, do you understand what it is you're charged with, what the state said you did, when or how they alleged you did?
Yes, sir.
Do you understand the possible penalty?
Yes, sir.
Now, we discussed the nature of the charge, the evidence of the case, possible legal issues of the case, possible defenses you try to raise the trial, possible outcomes of the trial with your attorney.
Yes, I have.
And are you satisfied with his advice and confidence in this matter?
Yes, I am.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to get you to plead guilty here today?
No, sir.
Now, on page 2, there's a couple of sentences that are printed in bold and underlined. I'll read those. Defendant shall plead guilty to count 2, state will dismiss count 1. State will recommend community control and admission to drug court and STAR treatment. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, Mr. Krebs, the matter of sentencing is up to the judge, not the parties. So even though there's a recommendation that you get community control, once I've heard all the information, if I decide that's not the correct sentence, under the law and the evidence, I could go ahead and sentence you to a prison term. Do you understand that?
Yes, sir, I do.
Now, do you hold any kind of a license or certificate from any state governmental regulating board or any kind of profession or occupation?
No, I don't.
And you have certain constitutional rights, you must understand, before I can accept your guilty plea. First of all, you have the right to have an attorney in this matter. If you cannot afford to hire one, I'm sorry, and the court did appoint one for you because you could not afford to hire one. Now, I didn't appoint Mr. Armentrout simply to work the case out, but to provide whatever defense might be available to you under the law that you would like to provide. So if you decide that you don't want to do this, that you want to defend against this charge and the other charge, then he will continue to represent you, including a trial, if that's what you want. You understand that?
Yes, I do.
All right, Mr. Krebs, on the Constitution, you have a right to a jury trial in this matter, in which 12 people will be selected from a group of citizens from this county, summoned for jury duty under your trial date. After they were selected, the evidence will be presented, they'd be instructed on the law by the judge, and then that jury would decide by a unanimous verdict, meaning they all 12 would have to agree on whether the state proved your guilt of the charge. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial, and then in that case, you have what's called a court bench trial, meaning the judge would be the one to hear the evidence instead of the jury, apply the law, and decide whether or not the state proved your guilt, but proved beyond reasonable doubt. You understand that?
Yes, I do.
Right now, in the Constitution, Mr. Krebs, you have the right to confront witnesses against you and cross-examine them through your attorney. So what that means is that the witness against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions of the witnesses, then your attorney can ask questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
And under the Constitution, you have the right to use the power of the court to compel a fourth witness to come into court and testify for you, just like the state. So, if you have witnesses you're uncertain going to come in voluntarily, your request for this court order, that's a subpoena, and that forces those witnesses to come to court and be available to testify if they want to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have the privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, you make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person. No one can even comment about it except in one situation. That is, if there's a jury trial and you don't testify, then the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right, under the Constitution, Mr. Krebs, you have a presumption of innocence, which means that you're presumed innocent of this charge until proven guilty by the state of Ohio and every essential element of the offense charged by proof beyond reasonable doubt. So the burden isn't on you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you don't have to present any defense at all at trial. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now, originally you entered a plea of not guilty to this charge. That plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights that I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea admits the allegation in the indictment, admits that they constitute a crime, that you committed that crime. And that plea waives, gives up all the rights that I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty would waive, give up your right to a jury or a court trial. You would waive, give up your right to confront witnesses against you and cross-examine for your attorney. You would waive, give up your right to compel witnesses to come to court to testify on your behalf, the same as the state. You would waive, give up your privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty. You would waive, give up your presumption of innocence because you say you're guilty, then the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. Finally, the waive gives up any right to file an appeal, which you think you may have had up to this point in the case. Now, if I should sentence you to maximum sentence or under other certain circumstances, you file an appeal, that would have to be filed within 30 days of the sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right, now you have any questions about the charge and possible penalties?
Yes, sir.
Do you understand?
Yes, sir.
Do you have any questions about the plea agreement?
No, sir.
Do you understand?
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
Do you understand that?
Yes, sir.
Is there anything you need to speak with Mr. Armstrong about before we go any further?
No, sir.
Do you have any questions about anything that I've explained here this afternoon?
No, sir.
Then is it your decision, Mr. Krebs, to withdraw your not guilty plea, plead guilty to count 2, pursuant to the terms of the written plea agreement we just got over?
Yes, sir.
I don't know if I asked you this, but if I did, I'm going to repeat myself. I'm sorry, but are you a U.S. citizen?
Yes, sir.
Okay. All right. Then as to count 2, that alleges that on or about December 28, 2021, in Highland County, Ohio, and as a continuing course of criminal conduct in Ross County, Ohio, you did knowingly obtain, possess, or use a Schedule 2 controlled substance with a fentanyl-related compound in violation of Section 2925.11 of the Ohio Revised Code. Charge of aggravated possession of a fentanyl-related compound, a fifth-degree felony carrying possible prison term between 6 and 12 months, a fine of up to $2,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this day no court defendant provides all his constitutional rights made in no intelligent voluntary way of the same pursuant to Criminal 11. Please accept it when filed. Defendant found guilty in count 2. As charged therein, count 1 is dismissed. The court will order a pre-sentence investigation under the same bond. That will include an assessment for drug court, or a referral to drug court, and an assessment for substance use and/or mental health disorder treatment. Sentencing will be on April 13th at 9 a.m. All right, is there anything further from counsel?
No, Your Honor.
Yes, Your Honor. On behalf of Chancellor, I have a letter that I received today from his father, Tim Krebs, actually brought down on Tim, and his sister Julie, who is Chancellor, was at hand. I know the court's familiar with Tim Krebs. Chancellor, that he could reside with her. Chancellor's indicated to me that he would like to, I think he may have done it before, but he would like to get on a Vivitrol program. We'd ask the court to consider releasing him between now and sentencing on no harm bond for him to pursue that. To whoever would love to do that, and he does have a place to reside, Your Honor.
Mr. Payne?
Statement would be strongly opposed to that. We've already gone through this bond review hearing. This defendant was originally granted medical furlough, never returned, ended up being charged with escape, and picked up these new charges. So the state is strongly opposed to that request.
Well, I would agree with that. I think that's probably just asking for problems, Mr. Krebs, because with your history, even though your intentions might be good, if you're still actively addicted and there's a trigger there, you could end up doing something else and end up in prison. I will say this: if there's a mission into, and I know the recommendation is STAR, but I normally try a regular treatment facility first, residential treatment first, because that's primarily directed for substance use disorder, or STAR is for thinking for change in the cognitive behavior therapy. So if he can be admitted into a residential treatment, I would release him to go there, but not to family home right now. I don't think it's fair to him to put him in that situation. So I'm going to leave it the way it is. All right? Unless that happens. All right, thank you. Okay, are you Brian Conley there at the jail? That's this case number 22 CR 21, State of Ohio versus Brian Conley. This hearing being, pre-trial being conducted by Zoom. He's appearing from the jail. His attorney is William Arnold, appearing from his office, and representing the state is Assistant Prosecutor King. The defendant is charged with 6 co-defendants. He's not charged with everything. He's only charged a couple of them. 21 and 22 with Jennifer Tyson. Aggravated trafficking, methamphetamine in the vicinity of the school zone, second-degree felony. Aggravated possession, a third-degree felony. I believe this is a first pre-trial, and final pre-trial is March the 16th, and trial is set for April 11th. Now I see that states provided bills of particulars and discovery. Have you provided your discovery yet to start traffic?
Sitting here looking at it, Ron, just needs to be filed.
Okay.
No surprises in it.
All right. And do you anticipate any pre-trial motions?
No.
And have you received a written plea offer from the state?
I have, it's actually revised when Mr. King's aware of it, my client's aware of it. And I do believe this matter resolves through plea, Your Honor, and probably will try to set that up even before the 16th.
All right. Okay. Any other matters that to discuss?
No.
All right. And,
Yes.
okay, thank you.
Judge,
Yes.
just for the records clerk, he's actually charged with the 2 counts you said and 4 more counts.
Okay.
29, 30, 31, 32.
That's correct, Your Honor.
Oh, okay, I see there now, yeah.
And
Okay.
those are the worst severest charges.
Yeah, okay, I see that, yeah. One's a first degree felony, yeah, and there's a 2 there as well. All right, yeah, thank you. All right, James Picklesheimer. Yeah, yes, yeah, they'll bring in Mr. Picklesheimer.
Your Honor, James not ready at the moment, so I'm waiting.
I'm sorry?
James is not ready at the moment, they didn't bring him up.
Oh, okay, just take a few minutes then. We have another, case coming up at 3 with, somebody from Dayton, so we'll wait on you.
Okay, thank you.
You can go now if you will.
You Mr. Lanigan? Oh, okay.
He's a grandparent of Conley.
Stepfather,
You just heard.
Conley, you spoke,
Oh, okay, all right. Okay.
just ear for ears for the mother.
No, that's all right. That's, we welcome that. I prefer people come to order. You can also watch on YouTube, so you can hear what, see what's going on. Save your trip.
I've heard that time.
Okay,
Hey, thank you, Mr.
okay. Thank you, anytime.
Okay, I just muted you, just so you.
Are you James Picklesheimer appearing there from jail?
Yes, sir.
Okay, this is case number 21-178. State of Ohio versus James William Picklesheimer. This hearing, pre-trial is being conducted by Sue. Is appearing from the jail. His attorney is William Armstrong. Appearing from his office, appearing on behalf of the state is Assistant Prosecutor King. Defendant is charged with aggravated possession of methamphetamine 5th degree felony. I believe this is our first pre-trial. and final pre-trial, I believe, is coming up,
Actually, the final.
oh, it is actually the final, that's right. Trial actually set for 21st. Okay.
We never had a first pre.
Yeah, we were going to do a video, and then, there was a problem, with the institution, we couldn't do it, I forget now.
We
What
tried
happened?
a couple times, I think one of them might have been the snow day and.
Yeah, I think you're right, okay.
And tried it twice.
All right, so this is actually the first pre-trial, okay. All right. Have you had a chance to speak with him yet, Mr. Armstrong?
Yeah, he's been back here, I think, since the 25th of February. I wasn't aware of that. I spoke with him today.
Okay.
Went over we went over the evidence, and I believe this matter was all successful. And what the offer was, I really haven't had a chance to speak with the prosecution about it. He was just released. He just did a year for fake. I mean, this is a low-level possession charge, Your Honor, but I believe we've got to resolve it. I'm not going to ask to continue anything, but I'll probably just get with your assignment commission, try and get something set up in the next 3 or 4 days here.
All right. Well, by chance something should work out, since we've only had one pre-trial, we're going to have another pre-trial, or if you need to continue the trial date, since the first pre-trial got canceled, you didn't have a chance to talk with him, just let me know, and file a motion, and we'll be able to then. So he's being held now on the charge here since his release from prison.
That is correct. Okay. In that line, I would ask the court to consider the bond. The bond's only $2,500 right now. He doesn't have any funds to make any kind of bond at this point. And quite honestly, Your Honor, he'd like to obviously be out for a few days before we resolve this matter.
Okay.
The state would be opposed to a bond reduction on. This defendant was released from prison within the past week. He's not a Highland County resident. I'm looking at his priors right now. He has an extensive criminal history. I fear that if he were given an OR bond, we would not see him again until he was picked up on a case.
What was the sentence that he was just released from prison? What was his offense?
It looked like he was sentenced on 2 possession charges and a felony non-support. Total sentence of 1 year, so it must have had. It's like he served 1 year out of Fayette County.
Okay. Well, I am looking at quite an extensive record here, and some of these offenses even are offenses of violence, mostly misdemeanor, but some significant charges. So I'm going to leave the bond in at the word it's minimal bond, and I think that's necessary to make sure that he doesn't appear. All right, anything further? All right, thank you.
Can I plead out today?
You need to talk to your attorney. We can't do it today. Yeah. All right. Now, who's appearing from the probation department? What's your name, sir?
Your Honor, it would be David Lanigan here from the probation department.
Oh, okay. All right. That's Mr. Lanigan. All right. Thank you. Mr. Lanigan, you're muted there. There you go. They got you. All right. This is case number 22 CR8T, State of Ohio versus David A. Lanigan. Here's David Lanigan appearing from the probation department by Zoom. Okay. Mr. Lanigan's attorney, Mr. Brennan, is present, Dr. Brennan, and representing the state is Assistant Prosecutor King. The defendant is charged with trafficking cocaine, possession of cocaine. Those are third-degree felonies. This is the first pre-trial. Final pre-trial set for the 5th of April. We have a jury trial set for the 14th. I see that the state provided discovery, looks like back on the 9th. Was there no particular request? I don't see one.
There was a night.
Okay.
And not to cut you off, I could probably expedite this a little bit. I have had some discussions with Ms. Collins. I do believe we are going to be able to work this out. And perhaps we can convert the final pre-trial into a change of plea.
Okay. That'll work. We do a lot of them then. That will be, I'm planning on doing all the pre-trials starting after next week. We're going to move back to in-person unless people want to do Zoom. So, we'll anticipate that being here. But again, if you want to do a Zoom hearing, I'm also going to do that as much as we can to accommodate people.
Sure.
All right. So we'll just look, and if it's not worked out, your discovery, we do invite the client to retrial, and any pretrial motions, again, if the case is not resolved. Okay, any other matters we need to discuss then, counsel?
I don't think so.
All right. Okay, thank you very much, and I think that concludes the docket then, doesn't it?
Yes, sir.
All right, thank you, officer. Yeah.
I had Jennifer Isom down on, are you supposed to see her?
She's already planning.
She pledged, yeah, we already taken care of her case, yeah.
Okay,
Yeah, it just didn't get taken off the docket, apparently.
Okay,
Thank you. Well, that was an intense 2 hours.
It was.